Well, day one of Peter Ridd's appeal hearing in the federal court has now wrapped up. I'm Gideon Rozner, Director of Policy at the IPA, and I'm joined now by Evan Mulholland, our Director of Communications, to give you a bit of an update and chat about the day's events on what is quite possibly the most important case on free intellectual inquiry in the history of Australian jurisprudence. And we saw that from the fact that precedent and prior law on this is scanned on the ground, that a lot of law had to be read in from the United States and from authorities overseas. But as with the last hearing that Peter Ridd, of course, won in the Federal Circuit Court, a lot of this case hinged on the definition of academic and intellectual freedom in Clause 14 of the Enterprise Bargaining Agreement. So, Evan, what do you make of some of that discussion today?
Yeah, look, we saw JCU trying to construe, again, as it did in the Federal Circuit Court, academic freedom as narrowly as possible. So we saw examples of where they described intellectual freedom as also applying to cafeteria members or groundsmen at the university, as to try to disconnect the idea of the university from the case itself and make it into a more bland industrial dispute and disconnect the idea of the university away from that.
Yeah, well, that's right. The contempt... Well, I wouldn't say contempt, that might be a bit of a strong word, but the lack of a premium that the university puts on intellectual and academic inquiry was on display, whether it be the fact that Brett Walker, the top QC hired by JCU, referred to them as so-called rights, not rights, as Stuart Wood said repeatedly. They're not so-called rights, they're very important academic rights. In fact, they are rights. Yeah. They are rights central to the mission of a university. Without academic and intellectual freedom, a university could not exist in the form that we like to think of it as. So we saw that very much on display, and I think in trying to say, well, it applies to all staff, so it doesn't apply to groundskeepers and cafeteria staff and all the rest, they were trying to make this point that it's, as you said, they're trying to turn it into another vanilla industrial instrument rather than focusing on what we've discussed today as a really unique feature of the EBA. So we've talked about the academic freedom clause of the EBA and how important and how central that is, but as usual, the key tension, and for those of you that are still catching up on the facts of the case and the key legal issues here, the key issue is what has precedence. Is it the Enterprise Bargaining Agreement that it was negotiated between the NTEU and James Cook University that protects academic freedom as a matter of right and of contract?
Yeah.
Or is it the Code of Conduct written by JCU administrators that requiring all sorts of things like respecting the reputations of colleagues and collegiality and things like that were used to read the academic rights, the academic freedom right rather, narrowly. So in other words, the university was saying, look, it's not what Peter said necessarily, it is the way in which he said it. It's the fact that he said science couldn't be trusted. It is the fact that he said that certain colleagues might be spinning a story for their own purposes. He did put forward robust disagreements with what had been said, but nevertheless they are very important matters of scientific disagreement.
Yeah, what JCU are attempting to do here is redefine academic freedom within the bounds of collegiality. That completely turns on its head the idea of the search for truth, the idea of free and open intellectual inquiry, which is what a university is meant to be about. If a university now becomes the search for truth within the grounds of collegiality, that's completely up to the university what academic freedom is, whether it's collegiate or not. That completely turns on its head all the rights of academic freedom we've worked so hard for. And it really would have a massive chilling effect if the federal court is to write into law that academic freedom must be collegiate. Can you imagine all the other professors and academics out there that will be second-guessing themselves when questioning research?
Well, that's right, and that's something I've discussed with Peter, in the past, that, look, the fact that you should be collegiate and respectful of colleagues is all very well and good, but when it's so vague and so well defined in this case, nobody wants to be the person who might overstep the mark. Nobody wants to be the person who lands in that grey area and steps on a landmine like Peter did, especially, I might add, if you're a younger academic, somebody at the start of their career, somebody who doesn't want their name blackened with a lot of this stuff. You're absolutely right. It puts a very, very definitive chilling effect on intellectual freedom. Now, Lord knows I've disagreed with a lot of what academics have had to say in the course of their professional output. But I will defend to the death their right to say it. The fact of the matter is we are spending billions of dollars in Australia on public squares of open learning, and if the university administration gets to decide what's fair game and what isn't, we'll end up in a situation where so many of the ideas coming out of universities that challenge prevailing orthodoxies are basically off limits.
Yeah, and you speak of chilling effects, Gideon. We've now got a university spending millions of taxpayer dollars going to a further court in attempt to silence one of its own professors from speaking out on a very, very important topic such as climate change, which we spend millions and millions, if not billions of dollars on taxpayer funding, on Great Barrier Reef marine science, on very important areas of public policy which receive millions of dollars. One would think that in itself is a chilling effect to every other academic out there who'd like to speak out on this issue.
Well, it's been an interesting day today, and no doubt tomorrow will be as well. So please continue following along as we provide an update on Peter Ridd's second and final day of the appeal hearing in the federal court. And for those of you that haven't caught up on the facts of the case just yet, please do remember that we have our new podcast, The Heretic, inside Peter Ridd's fight for freedom of speech on climate change, out now on iTunes, Spotify, YouTube, and at ipa.org.au/The Heretic. And for all other work in this area, please do head to ipa.org.au/Peter Ridd.